Ramos.
Good morning, everyone. We'll call the meeting of the Advisory Council on Workers' Compensation to order. It is 10:03 in the morning on Monday, March 23rd. We are in room 31 of the Legislative Plaza in Nashville, Tennessee. Ms. Schroeder, would you call the roll, please?
Christy Allen.
Here.
Carrie Dove. Bruce Fox. Here. John Garrett. Here. Bob Pitts.
Here.
Gary Selvey. Here. Paul Schaefer.
Here.
John Burleson. Paula Claytor. Sandy Fletchall. Dr. Graves. Abby Hudgens. John Harris. Oh, was on the phone. All right. Lynn Lawyer. Jerry Mayo. Dr. Merle. David, did everyone get disconnected, you're saying? Greg Ramos. Mike Shinnick. Senator Johnson. Representative Eldridge.
And we have a quorum. I think we're still waiting to get a couple of members reconnected on the telephone. They are non-voting members. Our voting members are all here for a quorum. Once again, my name is Christy Allen. I'm the Assistant Treasurer for Legal, Compliance, and Audit in the Tennessee Treasury Department. Chairman David Lillard was unable to be here again today, and He apologizes. He is out of town in Washington, D.C. at a National Association of State Treasurers legislative conference and has asked me to serve in his stead today, and it's my pleasure to do so. Before we go on with the rest of the agenda, I'd like to look at the order of the three bills that the council is going to review today, and in the interest of efficiency of operations, I think I'd like to move the last bill for consideration, House Bill 1073, Senate Bill 1328, up from the number 3 spot to the number 2 spot. So we'll consider that second, and unless the council has an objection, we'll proceed in that way. Are there any other changes to the agenda? All right, seeing none, we'll move on to the approval of the minutes. Has every member had an opportunity to review the minutes? We have a motion to accept the minutes. Do we have a second? Second. Mr. Pitts?
Madam Chairman, in the interest of clarity, I'd like to ask Bruce if he has any objection on the firefighter issue, if at the appropriate location it was to make a comment that the principal concern of the 3 employee representatives was the application of the 40-hour concept to part-time volunteers, just so people will understand what our concern was.
I have no objection to that being stated on the minutes. I would point out that if you have a new employee, let's say injured the first afternoon they're on the job, that's the methodology that's utilized, is to take the average weekly wage for a similar situated employee and apply it to that person. I think that's what they're trying to accomplish. But as far as amending the minutes to reflect your concerns, I have no objection.
No. Is it all right with you for the second? All right, so Ms. Schroeder is taking down the additional language. Would you like to read back what we think we're going to put in the minutes?
Oh, I totally didn't get that in there. No.
Okay.
I'll have to listen to the tape.
Let's do it. As long as there's no objection from the council. We have a motion and a second to approve the minutes as amended here today. Ms. Schroeder, would you take the roll?
Carrie Dove. Bruce Fox. John Garrett. Bob Pitts. Gary Selvey. Paul Schaefer. It's unanimous.
Thank you. We'll move on to new business on the agenda. The first item under legislation review is House Bill 589, Senate Bill 1061. I believe Representative Parkinson is here. Welcome and good morning.
Good morning.
If you'd please give the council a summary of your bill and start discussion.
Happy to. I'm making a little room up here. What it does is this. And the bill is amended. I don't know if you guys got a copy of the amendment or not.
Yes.
You do have a copy of the amendment? Okay, and so it's amended for public employees only. And what this bill does is this. It makes provisions for those employees that are outside of the Drug-Free Workplace Act, outside of safety-sensitive positions, in cases where they are drug tested, it makes it so that there's no adverse action taken against them if the drug test comes back positive, but only if they legally were prescribed or are using those drugs in a legal case, in a legal situation. Let's say, for instance, if there's an employee that uses medical marijuana, I'll just use that as an example, and they go to Colorado or places where medical marijuana is legal, then if they were to come back and receive a drug test from their employer, then the employer has to factor in also whether or not this employee was under the influence in the workplace. And that's basically what this legislation does.
Thank you for that summary. Is there any comment?
So it would only apply to prescribed marijuana, not recreational marijuana.
It's prescribed marijuana or any drugs that's prescribed by a doctor in that case. But prescribed marijuana is one of those situations. And what happens is this: marijuana, in the case of marijuana, and this is not only for marijuana, but in cases of marijuana, marijuana stays in your system long after the use has been. Long after the individual has used the marijuana. And it's not the marijuana in your system, but it's the THC. Your THC level is still elevated. So you can use marijuana 2 weeks prior to going back to work on vacation, or if you're prescribed. And then when you come back to work and they give you a drug test, your THC level in most cases is still elevated, but you're not under the influence of marijuana. And as it's been... I'm trying to choose my words correctly here. In most cases, in the workplace, drug testing outside of random drug testing is the purpose of it is simply to make sure that we have a drug-free workplace. Make sure that no individuals are not operating or working in the workplace or on a work site under the influence of drugs, but not necessarily so much testing to see their history of drugs. And so in this case, what this does simply is allows those individuals that are legally prescribed certain medicines or medications or drugs, or in some cases medical marijuana, to have use of that medical marijuana in the places where it's legal, and not be subject to adverse actions from their employer when they come back if they still test positive for that marijuana.
Further questions from members of the council? Mr. Pitts?
Madam Chairman, I'd like to pose a couple of questions to our administrator for any thoughts that she might have. The first problem that I see, and if there's someone in the audience from the insurance industry or anything that has a thought, I'd like to hear it. My two questions are this. While this would allow it if the person is carrying a prescription, there's no way to know whether the marijuana is from a prescription or acquired after one returned back to Tennessee. So from an enforcement point of view, is it really of any value? And then my second question is, if this would be good for government employees, why would it not be good for anybody? And I'd like to hear your answers to that.
Ms. Hudgens?
Well, let me answer the last one first because that's the easiest one. I don't know of any particular reason why it should be just for government employees, especially since this bill exempts safety-sensitive positions. The other question is there any way to know where that prescription came from, or whether one might have had a written prescription but actually did not receive the drugs from that prescription? Before I do that, I just need to ask one question to clarify. As I understand this rule and your explanation, which was helpful, what I'm understanding you to mean is that if someone goes to Colorado or Washington, someplace where it's legal to purchase marijuana, whether with a prescription or just over the counter, this bill is to protect someone if you ingest it in a state where it's legal and then come to Tennessee, and you're concerned that because of the life of the TCH, someone might be given a reprimand or fired because it was still in their system. Typically, those types of situations are addressed by a medical review officer. If you have a drug-free program, you will have a medical review officer, and his job is to look at the prescription, talk to the employee, and determine how long it's been since the ingestion and whether it could have an effect. So it appears that drug-free workplace programs have been structured in a way to address the concern that you have. Unless I'm missing something.
Well, thank you, ma'am. I think that's a very good point that you're making, but this is notwithstanding any rules involving drug-free workplace. So this is anything outside of that.
If it's outside a drug-free workplace program, you're really talking about an employer's right to take a disciplinary action against an employee even though they don't have a drug-free workplace program. Is that correct?
We are talking about that, and we're talking about the fact that if there are no circumstances that would show this employee being under the influence at the time that you are drug testing, then that needs to be taken into account. It does not stop an employer from drug testing. It does not stop them from doing any or performing any random drug tests. It simply says that if they are if an employee has the ability to receive medicinal uses for whatever drugs, and it's not just marijuana. It can be another drug prescribed by a doctor. As long as they are legally using that drug, then this is where this would kick in and give them the ability to add the fact that there was there were characteristics being shown by that employee at the time that they were drug tested.
It does seem to set up a whole new area of litigation between an employee and an employer, because you'd have to argue about whether or not the circumstances of an injury actually could be traced to the presence of marijuana or to some other factor. The problem that still exists is that use of marijuana is still illegal in Tennessee, isn't it?
It is illegal in Tennessee, but we're and thank you for that. But we're speaking in regards to individuals that used it legally, whether it's marijuana or any other drug that was used legally. And if it's illegal in Tennessee, then you cannot use it in Tennessee. And
so we're talking about a very small window of time.
Yes, ma'am.
And it's hard to see whether this bill will provide any meaningful relief. I would think that if someone is under a prescription, there's a whole raft of issues with that, because if they're under a prescription for medical marijuana and they can't take it, and they're a worker in Tennessee, you see what the problem is.
If you're under, I believe that there will be, without putting the cart before the horse, but there will be legislation that will provide for legal medicinal marijuana passed this year.
I think you've given us the
right,
answer. We
right.
need to wait until that's passed.
Well, I'm not so sure about waiting for that to pass. We still have individuals that still use can legally get and receive medical marijuana in other states. And not just that, but we're not just talking, let's not make this all about marijuana, because it's not just about marijuana. This is about any legally prescribed drug that your doctor gives you. So it's not just about medicinal marijuana, and I don't want to make this the medicinal marijuana bill. This is any drug that is legally ingested by an employee. And so that could be your prescription drugs that your doctor gives. You can take a prescription drug that your doctor gives you the night before and still have traces of that drug in your system when you come the next day, and if you receive a random drug test. So this is not simply a medicinal marijuana bill, but the medicinal marijuana does fit into the bill.
If an employer is doing random drug tests, they're going to have a reasonable drug and alcohol policy. And those policies will require, go back to the medical review officer, those will require that the medical review officer give an employee an opportunity to write down every prescription that they take, and the presence of those prescriptions must be absent. That must be taken off the board as far as what would be considered a positive drug screen.
And I've taken one of those drugs. I'm a firefighter also. For those of you that don't know, I'm a lieutenant on the fire department for 25 years. And I've taken those drug tests also and been asked to declare what drugs or prescriptions I've been taking. But no one has ever asked me for proof of it either. Just declare it. So anyone can declare any drug in regards to a drug test that they're taking. But the point is that if those individuals are not exhibiting signs of being under the influence in the workplace, then we should be looking at that, because what is the purpose of the drug test? Are we looking for a history as to whether or not this individual has done drugs ever, or are we looking for to ensure that our workplace is secure and free of drugs, and making sure that our workers are not under the influence of drugs in the workplace? I think our purpose is to simply ensure that we don't have individuals that's coming to work that are high or under the influence of alcohol, for that matter, or under the influence of drugs, and exhibiting those signs of being under the influence of drugs in the workplace. So now, or we can continue down the path of infringing on everyone's rights and seeing if individuals have ever used drugs. I mean, if I was to take a drug test right now, who knows? I hadn't done any drugs now. Just let me make sure I'm perfectly clear. But if had I done drugs 20 days ago, and I come and take a drug test, are you firing me or reprimanding me because I smoked marijuana in Colorado 20 days ago? Or are you firing me and reprimanding me because we want to make sure that I'm not under the influence while I'm at work on your work site? Now, that's the question that needs to be asked, and that's what this does. We just want to make sure that those employees that for whatever reason their doctor prescribes them their medicine, and it's not our business to decide what's good and for them and what's not. It's their doctor's business and their business. So we just want to make sure that they're not under the influence in the workplace, and that they're not removed from their job or reprimanded in cases where their doctor decides this is good for your health and we need you to take these drugs.
You've done a wonderful job of explaining the values of a drug-free workplace. Just would add that one of the components of a drug-free workplace is to provide disincentives to using drugs at all, and that's where you get into the value of a drug-free workplace, because you don't want to have that argument about do they have something in their system that was there 20 days ago. You want to have a culture where they don't use drugs at all.
And that's that, and I agree with you 100%. But this legislation is for those employers that are outside of the Drug-Free Workplace Act.
Just to answer the question I was originally asked, which was, is there any way of knowing whether this legislation will accomplish what you're trying to do? I think it's a worthy purpose. I don't think it's written in a way that would have a meaningful result, however.
Okay, thank you, ma'am.
Ms. Lawyer?
Just to follow up, I thought this amendment was for the drug-free workplace programs.
No, ma'am.
The first sentence on our description says that, and that was what I related it to. Is that inaccurate?
That's very inaccurate. Yes, ma'am.
Okay. So just for clarification purposes. And then secondly, I guess my concern is, who are we trying to address? So we're trying to address people who leave the state of Tennessee to seek out illegal drugs through prescription. So are we addressing people who are leaving Tennessee to seek medical treatment in Colorado and get a prescription for marijuana or some other type of drug? And so we're addressing those people who are going outside of the state to get medical treatment and then coming back, because at least the drug-free workplace has a presumption that can be overcome by medical proof that it was not and did not lead to the work injury. And so that kind of takes care of the people who may have done it 20 days ago and it did not affect their on-the-job injury today.
No, ma'am. We're addressing any Tennessean that, whether they're in state or out of state, that has a legal either prescription or legal use of drugs. Period. Whatever that drug may be, we're addressing those individuals, saying that if they're not showing signs of being under the influence in the workplace, then why are we having or creating an adverse action against them? Because their drug test their drug test came back positive. But a drug test, and this is the only thing we're trying to explain here. A drug test can come back positive, but an individual not be under the influence of drugs, and that's what this addresses.
Mr. Ramos?
Thanks for your comments, Representative. I'm a lot clearer on these things, but I wanted to ask you this. So you're saying today that this bill really goes beyond the drug-free workplace program, and it affects employees who are not part of that program, in other words.
This bill operates outside of the drug-free workplace.
Okay,
Yes,
got
it doesn't expand it, contract it, doesn't touch the Drug-Free Workplace Act, period.
And the bill as amended only applies to public employees.
Yes,
right?
sir.
Can you? I don't have an idea of this. Can you give me an idea of the public employees in Tennessee who are outside the drug-free workplace program?
I can't name them exactly, but there are some. There are some public employees.
Is it a big number? I guess
I'm not sure what that number, but I can try to get that information for you and try to bring it back to you.
I guess I kind of assumed erroneously, obviously, that if they're public employees, they would be part of the drug-free workplace program almost automatically, but I know not automatically.
I was told by HR when we were drafting this legislation last year that there are some pockets that are not necessarily under Drug-Free Workplace Act. Yes, sir.
And one follow-up, if I can I get your thinking on, I heard what Abby said about the scope, but can I get your thinking on why this is restricted to public employees and not going beyond that at this point?
Yes, sir. Thank you. That's simply a legislative strategy. Sometimes you have to get something in the code to get it in the code, and some things you just don't want to touch at that time. So, yes, sir.
Is there any further questions from the members of the council? Seeing none, is council ready to make a recommendation of one kind? Mr. Schaefer.
I move that we recommend approval of this.
We have a motion to recommend approval. Is there a second? Going once. Motion fails for lack of a second.
Thank you. Thank you, Committee.
Thank you, Representative Parkinson. Mr. Pitts.
Madam Chair. You may want to hear this. I'm going to try another motion. I want to say to you, Representative, that I'm very sensitive to the issues that you've raised, and I'm comfortable this is deserving of further consideration. I just don't see it in the time frames we've got for this session. I'm fearful that as you have drafted it, all we're going to do is move this contest away from whether there are drugs in the system and get into all kind of legal and medical debate as to whether an amount of the drug in the system impaired the injured worker or not. Because of that, I'm going to make a motion that this advisory council go on record with a negative recommendation at this time. I would encourage, if that is what happens in the legislature, that perhaps some further study be done by the division to see if any other state has meaningfully developed something that meets what you're looking for, that maintains any kind of meaningful enforcement. And I say that out of respect to you, given time and circumstance, but that's my motion.
So you've heard the motion for a negative recommendation with, I think, the conditions, I think, that Mr. Pitts has stated. Is there a second to the motion? Second by Mr. Selvey. Is there any further discussion by the council? Seeing none, Madam Chair, please. Sorry, Madam Secretary, please take the roll.
Carrie Dove. Bruce Fox. John Garrett. Bob Pitts. Gary Selvey. Paul Schaefer. Unanimous.
Thank you, Committee.
As we stated earlier, we're going to move move the next item around on the agenda. So the next item we'll take up is House Bill 1073, Senate Bill 1328. The description is on the agenda. Exempts from the Fair Disclosure of State-Funded Payments for Pharmacists Act, plans that only provide workers' compensation coverage for the state of Tennessee. Is there anyone here who wishes to present this bill or speak to this bill? I think that Ms. Schroeder has received a statement from one of the sponsors that she'd like to read into the record.
Representative Kane sent this brief summary stating that this bill is to clean up last year's bill, House Bill 1787, which went through. It was originally drafted but wasn't intended to cover workers' compensation. He goes on to say that the language indicated that anything as a result of accidents would not be included, but it also said that if you were taking state funds, you were subject to the reporting requirements of the Fair Disclosure of State-Funded Payments for Pharmacists Act. Therefore, this bill is to clean up and reflect that it did not intend to cover workers' compensation. We do have Rodney Escobar here from the Treasurer's Office if anyone has any questions.
Are there any questions or further discussion from the council?
Madam Chair, just by way of further explanation, somewhere in the discussion about this, I was informed that if this bill did not pass, that it creates a problem for the state in the operation of its workers' comp activity, similar to our workers' comp program, because of the master contracts they have with pharmacy companies and providing drugs. And with that, I would move that we put out a favorable recommendation on this proposal.
Mr. Pitts has made a motion for a favorable recommendation. Is there a second? Second by Mr. Fox. Is there any further discussion from the council? Seeing none, Madam Secretary, please take the roll.
Carrie Dove, Bruce Fox, John Garrett, Bob Pitts, Gary Selvey, Paul Schaefer. Unanimous.
Bill goes out with a positive recommendation. The next item on the agenda is House Bill 997, Senate Bill 721, the proposed enactment of the Tennessee Employee Injury Benefit Alternative. This bill was presented last week and discussed at some length, and the council asked to defer it until an amendment was available. I believe that amendment is available and has been distributed to the members of the council. So, with that said, how does the council want to proceed? Is there anybody in the audience who'd like to speak, or does the council wish to start discussions? Please come forward and state your name for the record.
Thank you, Madam. Thank you, Madam Chair. Gary Moore, President of Tennessee AFL-CIO. I'd like to talk to the committee and express my concern about some of the negatives that I think impact that it has on employees. And again, I'm talking about the original bill. The amendment may have taken some of that out. I'm not aware of. I haven't seen the amendment just this morning at the very 11th hour, if you would. But under the current bill as it's proposed, on the medical expenses, it's limited to 156 weeks or $300,000. That's not the case under the current law. It also, on the death and dismemberment, up to $300,000, and that's capped at $300,000. Under the current system, I don't need to tell all of you what the current system does, but it's better than the proposal, let me assure you. Permanent disability, there's none. And there's nothing to provide for temporary disability. The current law provides for both. Funeral benefits, there's none. Current law provides for funeral benefits. I think you're seeing the trend here. It's detrimental, in my opinion, to the employees. It's taken away much needed coverage that the employees would have under the current system. Also, custodial care. Under the proposed legislation, there is none. Under the current legislation, there is. Hearing aids, I happen to have worked in a department where I have to wear hearing aids now because of loss of hearing and job-related. Under this proposal, there is no provision to cover any kind of hearing aid loss, and it is under the current system. Artificial limbs, and this is really a sad situation. If an individual is injured under this proposal, there is no coverage for artificial limbs. Under the current, there is. Limited on the lump sum payment. And get a load of this now. Pardon my southern French there, get a load of. But I think y'all hear what I'm saying. Under this, the employee has no say at all. The employer determines what he or she is reasonable for that employee. And under the current system, there's no limit. Statutory to protect workers for medical benefits, 450 weeks. It's a big difference. Again, the trend keeps moving along here, as you see, where it's detrimental, in my opinion, to the employees. There is no, at least that I can read in the bill, no type of regulatory authority at all. The employer basically does what they want to at will under this system. Under the current system, you do have some regulatory authority set under the Department of Labor and Workforce Development, monitors the current system and makes sure that the employers are complying. There's no such mechanism under this proposed legislation. I would question, and I'm no attorney, I should have stated that on the front end, but I would question the legality of it, to be quite honest with you. Whether you, and I'm sure our legal drafted this, and I'm sure that they feel like it would be, but my lay opinion, I would question whether or not it's even legal to set that type of system up. And last but certainly not least would be the governor, as most of you know, went through a comprehensive worker comp reform just recently. And to my knowledge, there's no data out there to reflect how this system is even working right now. So I would encourage you to wait, and let's let the governor's workers' comp reform have an opportunity to see how it functions and see if it moves along in the manner in which the governor certainly thinks that it would. That's my comments, committee members. I appreciate your time, and I'll be glad to answer any questions you may have of me.
Members of the council have any questions for Mr. Moore?
Thank you.
Thank you very much. Did anyone else wish to speak to this bill? Come forward, please, and state your name and who you represent.
Good morning, Madam Chair, Commissioner Hudgens, Representative Eldridge. My name is Trey Gillespie. I'm Senior Workers' Compensation Director for Property Casualty Insurers Association. We're a national trade association that has over 1,000 members nationwide that write approximately 38% of the private workers' compensation insurance market. I've presented to Ms. Schroeder earlier today some written materials that hopefully have been dispersed that basically in some ways summarizes our positions. First page basically has some policy statements. Second page shows basically how the bill compares to the current Tennessee workers' comp system. And 3 raises some issues about turning Tennessee opt-out or the Tennessee alternative into an ERISA program and the consequences that has on the ability of Tennessee to oversee its workers' compensation injuries. We believe that this bill basically violates the grand bargain that's been in place for workers' compensation for over 100 years. That grand bargain that's been described in almost all jurisdictions basically identifies an agreement between the legislature, employers, and employees that a no-fault system would be put into place that would provide limited but certain benefits in exchange for tort liability protection for the employer. The key to this bargain is that it is the legislature that sets the benefits and all the conditions and limitations on eligibility to those benefits, and that the legislature also decides on what's covered by workers' compensation. What this bill does is it removes that part of the bargain. Under this bill, the employer can unilaterally set the level of benefits, all the conditions and limitations on the benefits, can set what the coverages are, while providing no meaningful dispute resolution system for the injured worker. This is not the first time the state of Tennessee has looked at the concept of opt-out for its employers. It was looked at, obviously, 2 years ago as part of evaluation of the workers' compensation system as a whole, and was not made part of the Tennessee Workers' Compensation Improvement Act of 2013. The state, as you know, hired an independent consultant to look at the advisability of opt-out and whether or not this would enhance the workers' compensation system in Tennessee. Work Comp Strategy basically wrote a detailed report in terms of its recommendations for workers' compensation reforms and concluded that there would be an adverse impact on employee benefits, among other things. In doing so, they were looking largely at the Texas opt-out system, and this bill is based very strongly on the Texas opt-out system. And consequently, their recommendations are still relevant to the discussion here in 2015 as to whether or not opt-out is a reasonable alternative to workers' compensation in Tennessee. The third and fourth pages of my written materials shows a comparison of the benefits to be provided by even the amended bill compared to the workers' comp system. Key to the bill are the handling of the medical expenses. I believe that the amended bill provides a $500,000 limit, but also a 156-week payment. But you have to understand that this does not pay for all reasonable and necessary medical expenses. It only covers covered medical expenses. And the employer can decide what medical expenses it will totally exclude. Consequently, the employee is liable for all medical expenses not covered by the plan, all medical expenses in excess of $500,000, all medical expenses incurred more than 156 weeks after the injury, and all medical expenses incurred after the employer terminates medical benefits. And you can put conditions and limitations into your plan that will potentially terminate medical benefits long before 156 weeks runs. And it's done all the time in terms of the way the operation has worked in Texas. Obviously, in workers' compensation, there's no employee liability. Obviously, $500,000 sounds like a hell of a lot of medical expense, and it is. However, if you go to NCCI and find out how many cases have already exceeded $500,000 in expenses, you will find that there are over 1,000 open claims in the Tennessee workers' compensation system in which more than $500,000 in medical expenses have been paid. One of the extreme cruelties that shows up in this bill is the bill provides, among other things, that once an employer has been certified to be a qualified employer, that basically open claims in the workers' compensation system are removed and put under the benefit plan. If you have a saturation that's common in Texas, where you have about 33% of your employers not providing workers' compensation, then you've got about 350 files out of these catastrophic losses that are still open claim files that can be transferred into an employee benefit plan, and medical benefits terminate at that point in time. The employee has nothing to do with this. This is obviously good economic strategy. According to NCCI also, that for cases in which basically the medical treatment exceeds 156 weeks, that 35 to 40% of all the medical expenses incurred in the case are incurred after 156 weeks. Consequently, who's going to pay for those bills? It's clear it's not going to be paid under the Employee Benefit Act. Under the benefit plan. There's no provisions for the employer to provide vocational rehabilitation services. There's some indication that temporary total disability benefits might be enhanced, but when you look at the fine line, you see that they're actually subject to payroll taxes, and consequently the net that may be received by the injured worker may actually be less than under the Workers' Compensation Act. And in addition, the duration of temporary total benefits would be limited at, excuse me, at 156 weeks, whereas it's not under the Workers' Compensation Act. There are provisions in there for the maximum combined for medical and indemnity. No such limitation exists in the Workers' Compensation Act. This basically undercompensates injured workers who were part of a catastrophic event. But remember that injures or potentially kills a number of workers. But remember that basically the employer sets what the coverages are. In workers' compensation, as you may know, workers' compensation cannot exclude terrorist risks. And indeed, unfortunately, we've had some incidents where employees in the course and scope of employment were injured and killed seriously as a result of a terrorist risk. Nobody needs to be reminded of 9/11. Billions of dollars were paid for those losses, and deservedly so. The employer under these benefit plans can exclude terrorist risks. And they would not necessarily have to compensate their injured employees one penny. The death benefit is less. The funeral benefit, I think, under the amended now matches the funeral benefit under the Workers' Compensation Act. However, as I'll mention in later comments, by virtue of ERISA protection, there's a good chance the state will never be able to be allowed to increase that funeral benefit. Permanent partial disability and all forms of permanent disability are basically discretionary benefits. The employee has to meet all of the terms and conditions and limitations that are in the benefit plan in order to get those benefits. So what the bill says as far as the minimum limits are in some ways fairly illusory in terms of entitlement. Workers' compensation has a certain degree of entitlement to permanent disability if you sustain a permanent disability, and that's whether you go back to work at your regular job or you don't. That's not true with benefit plans. Texas employers regularly boast that they never, ever pay for permanent disability. Never. There are some new provisions in the amended about total and permanent disability. But once again, it's the employer that decides who qualifies for total and permanent disability benefits. And they don't have to have the same list that other jurisdictions have in terms of the qualifications. And in addition, they set all those terms and conditions. The terms and conditions, among other things, are that you've have to potentially have signed an arbitration agreement in order to remain employed with the employer. That takes away any access to any other dispute resolution systems. Potentially also you have to be an employee to get benefits under the benefit plan. Now, in workers' compensation, your entitlement to benefits is whether or not you're an employee on the date of the injury. But under the benefit plan, it doesn't have to be that. If you are terminated after sustaining that injury, you may lose your eligibility to receive benefits. Texas is an employment at will state. Oklahoma is an employment at will state. My understanding is Tennessee is an employment at will state. And under employment at will, you can be terminated for good reason, bad reason, or no reason. And if the conditions set up in the benefit plan are conditioned on your continued employment status and you get terminated, it doesn't matter how seriously you've been injured. Your benefits cease under ERISA. And most ERISA benefits, when you're talking about ERISA benefits outside of workers' compensation, likewise, your ERISA benefits stop when you quit being an employee of that employer. There are no protections for dispute resolution due process protections. In fact, what you commonly see in Texas is that the administrator is given broad discretion as to what benefits to pay and what benefits not to pay. If there is a dispute as to the benefits that are paid, then it goes to binding arbitration. The binding arbitration has, the employer potentially has the right, depending on the arbitration agreement, to select the arbitrator. It doesn't have to be a mutually agreed upon arbitrator. And common in Texas also is that the employee has to share the expense of the arbitrator, and if they don't pay the expenses up front, they lose the right to arbitration. Also in Texas, it has been fairly common that the arbitration doesn't even necessarily, pursuant to the arbitration agreement, take place in the same city where the injured employee lives. There are cases from El Paso where you have to have your arbitration agreement in Dallas, your arbitration in Dallas. That's roughly 750 miles away. There's a case on the books in Texas also where an El Paso truck driver was required to do arbitration in Indiana. That's extraordinary burden both in terms of financial and convenience. It certainly discourages tremendously the ability to even pursue dispute resolution even when there's a bona fide dispute. But even if there's a bona fide dispute, the employer has full authority and the full right to change the benefit plan at any point in time for any reason. It's not subject to any oversight by the state of Tennessee or even any federal government agency. The rules can change all the time. This, once again, violates that part of the grand bargain that's in which we are trying to provide some degree of certainty for the benefits. There's no data reporting, no basically general government oversight. In Texas, there's been bills for session after session after session to require a little bit more transparency into these benefit plans. The proponents of opt-out have successfully defeated those session after session after session. The work comp strategies not only talks about the damage to the employee's benefits and the employee's bill rights, but they also talk about potential damage to employers left in the system. Because by and large, the opt-out system is going to be very attractive to large employers. And when you take large employers out of your workers' compensation system, among other things, you take away the impact that their robust safety plans have on workers' compensation rates. And the work comp strategy talks about that impact. They also talked about the impact on Social Security benefits and TennCare. And I've kind of already alluded to it with regards to the catastrophic injuries that are still open in here. But that applies to all catastrophic injuries. 156 weeks frequently is adequate number of weeks of medical benefits. But there are numerous cases, and at least over 1,000 open cases in Tennessee where the 156 weeks has lapsed a long time ago. These are cases that have dates of injury of anywhere from 1984 to 2000 through 2012. Where do they go for medical benefits after the medical benefits are cut off? Where do they go for wage replacement benefits after the 156 weeks are run out? They've also basically expressed concern that basically an opt-out system would undermine the workers' compensation reforms. And we certainly echo that feeling and that sentiment that the workers' compensation reforms should become fully matured so that we can see exactly what the impact of the workers' comp reforms from the Workers' Comp Improvement Act are and see what adjustments potentially are even needed from those reforms. We think that the 2013 Act was an excellent act. The last page in my written stuff is once again the effect of ERISA preemption. And ERISA preemption is potentially staggering. Section 514 of ERISA preempts and supersedes, quote, any and all state laws insofar as they may now or hereafter relate to any employee benefit plan. And this is an employee benefit plan. By the express terms of the bill, they say ERISA over, and over again in the bill. And once you certify an employer to be a qualified employer, and he puts that plan into ERISA, good luck at ever making any changes to your law with regards to opt-out. ERISA preemption may preclude you from doing any regulatory oversight or potentially any statutory changes that may affect the level of benefits or the overseeing of benefits. It is a very, very dangerous part of this act. Now, most state legislatures don't have the stomach for delegating what has been traditionally an area of concern for the state to the federal government. But this act certainly, this bill certainly does that. This bill, as I said, primarily mimics a lot of what is done in Texas. In addition, it actually mimics some of the Oklahoma bill that was eventually passed. The Oklahoma bill is under constitutional attack. There have been a couple of challenges already filed. There will be more constitutional challenges filed. It has slowed the number of applications that have been filed for qualified employer status. I do not pretend to know how this bill stacks up with constitutional protections in Tennessee, but it has to be a big concern, and I echo basically the sentiments of the AFL-CIO in that regard. Consequently, I basically would recommend to the committee that this bill not be put online for approval. I'm open for any questions.
Thank you for your remarks. Do the members of the council have any comments or questions for Mr. Gillespie? Seeing none, thank you very much for being here today. So now we'll open the floor for discussion from the council, if there is any. Is there anyone else in the audience? Ms. Schroeder says there may be one additional speaker. Doesn't look like there's one. Mr. Ramos?
I just have a question from Ms. Schroeder.
Yeah.
During our last meeting, Senator Green indicated that he was going to try to provide us with some information about his assertion that there was high employee satisfaction. Has any of that been produced?
I haven't received any of those reports that you requested.
Oh, okay.
Thank you.
I really appreciate the presentation by Mr. Moore and by Mr. Gillespie. It was really informing. Thank you very much.
And I think we did have one more speaker. You'd like to come forward and state your name and who you represent, if you would, please.
Good morning, committee. My name is Brian Bivens, and I live here in Nashville. I'm a government relations consultant for the Association of Responsible Alternatives to Workers' Compensation. AROC is the trade term, and it's a national organization formed to advocate for a system that will deliver better medical outcomes to injured workers and give employers a choice in how they manage employee benefits. Just listening through some of the testimony this morning, I understand change is hard, but there have been a lot of Tennessee employers that have successfully run plans in Texas for years with better medical outcomes, higher employee satisfaction, and lower costs. The amendment before you has been a working document for over 5 years, and I believe it represents the best collaboration of stakeholders we have ever discussed as policy for Tennessee. I look forward to the council's comments and your recommendation. Thank you.
Thank you. Mr. Mayo, do you have questions for Mr. Bivens? You recognize Mr. Mayo?
I'm confused how we can say that we have better medical outcomes when we're destroying the medical benefits that employees currently have under workers' compensation.
I believe since there is not an option for Tennessee employers in the state of Tennessee, we would have to look at statistical data from Texas.
We don't have any.
If you would like to see some of that, I'm sure I could generate some of that for you.
Well, the question was that we're reducing benefits on the employees through this bill. Why are we doing that?
I think those questions would be more relevant to the sponsors of the legislation. I just wanted to get up and on behalf of employers state that this is they would prefer to have an option in the state of Tennessee.
Any further questions for Mr. Bivens? Thank you very much for your comments today. Anyone else? I think we have additional speaker. If you please come forward, state your name and who you represent, please.
Thank you. My name is John Peeler. I'm currently president of TAJ. This is an unscheduled talk, and I just happen to be here. I'm a trial lawyer over the last 20 years, a pharmacist for the last 30 years. I'm going to try to personalize this situation, if the bill were to pass, what it would do to just one of my clients. Now, I'm a small shop. I've got probably 30 or 40 clients, and so I'll just relay to you one particular instance that I've gone through in one client. The name of the client is Jack Meeker, and Jack and Mary live over in Dixon. Now, Jack he's a military man. He learned how to weld, and after he got through his military experience, he took a job inspecting welding. He worked 50 hours a week, did a lot of overtime, worked Friday to Friday, and collected his check and tried to make the payment on his house, his vehicles, his kids' tuition. Jack was working down in Memphis. He fell 20 feet, and he severed his spine. Now, it's a very serious case. They take Jack to the med, and they put in hardware. He immediately incurred hundreds of thousands of dollars worth of bills. They took him to Shepherd's, and he learned how to walk a little bit. The final result of that was Mr. Meeker was never going to have sex again. He was never going to walk again. Wasn't going to walk his daughter down the aisle. Had no control over his bowel or bladder. This is the state that he lived in for a period of years. He was in constant, unrelenting pain. He would sleep 2 hours at a time, wake up screaming in pain. He lost 60 pounds of weight, and his bills continued to incur. Pretty soon, his bills were over $1 million. His hardware failed in his back that was installed down in Memphis. He had to go to Vanderbilt. They redid the hardware. This time, they put in two rods, titanium rods, front and back. He had unrelenting pain year after year after year. Well, the point of all this was Mr. Meeker could no longer work. He was never going to work again. His bills approached $2 million. Years and years go by. He finally reached maximum medical improvement about 6 years. By that time, they had dissected his back and basically went in and cauterized all the nerve endings to finally stop the pain. Well, when you do that, you eliminate any possibility of having function in your lower extremities. My attempt is to personalize this and to say that Mr. Meeker was never going to work. He would have lost his house, and he almost did anyway. He would have lost his automobiles. His children would not have gone to school. And he would have basically been living under a bridge with his family if he would have been that fortunate. If he got hurt and this bill were in effect. So eventually he would have found his way to get some medical treatment, and where would that cost have been transferred to is the point. The state of Tennessee would eventually have probably picked up a portion of that cost, and I ask you to think of that when you vote on this bill, and I ask you to do not let this bill become law. Thank you.
Members of the council have any questions? Any other speakers from the audience today? Seeing none, we'll turn it back over to the council for discussion and perhaps motion.
So I'd like to
Mr.
comment,
Dove.
please,
Mr. Dove.
Madam Chairman. Certainly appreciate the comments from the members of the audience today and all of the energy that has been put into looking at this. We as a council are in a position to where we make a recommendation to the legislators if we think this is a viable bill. And certainly, I think from a business perspective, I respect the businesses that support this. They're of the highest integrity of businesses in Tennessee, and understand where they're coming from, and the experiences that they've had it from other states. So I understand that, and we also understand the position of the speakers that have come forward today, of the administration, and we're in quite a quandary here. We've asked for some information from the other states for their performance in the bills that they have with opt-out, and we haven't really received that. And given the fact that we received the bill as late on Friday and even more changes this morning, this is a very serious bill. And we did have a very good renovation of the Workers' Comp Act a few years ago that we were involved in, and we feel like that it's going to be successful. And this opt-out bill, however, is somewhat independent of that in some ways. And given the fact of the seriousness of this and the gravity of this, and not really understanding what the consequences of a decision, if we made and approved to recommend this today, I think it's important that we spend more time looking at this, and that we not only look at what the changes are, but the consequences of the changes, not only administratively, but also to the citizens of our state and the workers of our state, see what the true consequences for those folks are so that we can understand the gravity of this if we were to pass it. I don't think we have enough information right now, or certainly I don't, to make an informed decision to forward with that. So with that being said, are there any other comments? I'd like to make a motion.
Please proceed.
I move that the administration and public policy makers and the regulatory folks, along with other interested parties, engage a consultant, a respected independent consultant, to really study this opportunity and come back with data and information that will enable the council to make a truly informed decision to the legislators on which direction the state of Tennessee needs to go. And not only that, consider the opt-out bill itself, looking at the positive parts of programs from other states and what we can do to incorporate in an opt-out bill if that's the direction that the study tells us, or if there's a possibility of incorporating those improvements into the existing Workers' Comp Act so that we can satisfy the needs of those high-performing, high-integrity companies that have demonstrated that they are truly qualified to run a responsible program. That's my motion.
So we've heard the motion. Is there a second? Is there a second? Have a second from Mr. Schaefer. Is there discussion from the council? And we have Mr. Mayo's hand up first.
I appreciate your motion, believe it or not. But I don't think we need a consultant to tell us this is not a good bill or to tell us that the benefits are reduced. If we're going to do anything at all, we need to look at the bill and see how we can make it mirror the Workers' Compensation Act that's already in place. And if people want to, we still have issues on the Guarantee Fund we haven't even discussed yet. There's a lot wrong with this bill that will not be fixed by a consultant.
Mr. Pitts also had a comment.
Madam Chair, I would like to make an observation to Gary to see if he'd maybe like to extend his comments. It seemed to me what you've said so far lacks a couple of things. The first is those groups that you first mentioned, in my opinion, ought to be left the liberty to decide if they want to take that step, which you might offer as a recommendation. But what you're also missing is a motion of where we are on this bill today going forward, for consideration before standing committees this week. So one thought that comes to my mind, you could make the first part of this your declaratory statement, but at some point there also needs to be a motion on what the position of this council is now. That's my thought.
Mr. Dove? Do you care to respond to Mr. Pitts?
So to include in that motion that the parties I listed in the beginning determine if they would like to go forward with a study from a consultant. And I guess, Mr. Pitts, what you're looking for is if we recommend or not recommend this to go forward. My motion would be that we not recommend it to go forward at this time, pending the other action in the motion.
We'll consider that an amendment to your motion. Mr. Schaefer, accept the amendment as a second. So you've heard, yes, Mr. Garrett.
Thank you. Madam Chairman, I'd like to, before we vote, just give the opportunity to Ms. Hudgens whether she wants to comment on this bill or not. She may not want to comment, but I'm just sort of curious to see if she wants to or not.
Ms. Hudgens?
Did you and Mr. Pitts sign a pact to see about putting me on the spot this morning? These are my thoughts on this. And first of all, I would like to, even though he's not here, say to Senator Green and the sponsors that I very much appreciate the amendments that they came forward with on Friday afternoon. They do tend to bring the bill closer to the benefits that are available in this state law. It's a very large move that they've made, and I very much appreciate that. However, those benefits are still not on a par with what we provided in state law for employees who are injured. Beyond that issue, however, I have two large concerns. The first is that the law divides the current pool of employees into those who are eligible for benefits and protections under state law and one that does not. The second concern I have is about the fairness of what happens to those people in that second group. The employees of employers who have opted out. There are no protections or processes available from the state of Tennessee to help these employees get help if their employer is not fair in their dealings. Now, as Mr. Dove has said earlier, the sponsors, the people that we know of that are very interested in this bill are responsible employers. They are the backbone of employment opportunities in Tennessee. However, this bill applies to everyone who becomes qualified, and the qualifications have nothing to do with how well they may treat their employees. That's a concern for me because we need to protect all employees, not just those employees of people who decide to stay under the workers' comp law. It's troublesome to me that the state would only be able to say to an employee who has an unfortunate situation with their employer because the employer is not being honorable or just, is that their only option is to embark on a costly ERISA lawsuit. And that is a lawsuit that has very low probability of success or even low probability of being able to find an attorney who would represent them. The workers' compensation system needs to balance the interest of employers and employees. When we had the reforms of 2013, that was the primary objective, that we listen to the issues on both sides and chart a path that was fair. Now, the only evidence I have at this point that we may have successfully gotten there is we made both sides mad at us. So you figure if no one's really happy with what you came out with, we've at least made a good attempt at that fairness. I think that in the reforms of 2013, in part, were a reflection of this feeling that benefits had swung too far in one direction, and they were interested in a better, a more equitable spot. This bill seems to be taking us in the opposite direction. I'm concerned that it will do a great deal of harm, and I think that what the state must do, first of all, in all cases, is try not to do harm. In a nutshell, that's my position.
Any further questions, comments? Mr. Ramos, you wish to be recognized?
I just want to say that I appreciate all these comments, but the bottom line, Mr. Dove, I believe with your motion, do I understand it correctly that it would be a recommendation that this bill not move forward? That's the bottom line of it?
That's correct.
Okay. Then I just want to go on record as encouraging that. Thank you for all the comments from Ms. Hudgens, from Mr. Mayo before, and I think that's the way to go.
Thank you, Mr. Ramos. So you've heard the motion. Is there further discussion before the council? Is the council ready to vote? Ms. Schroeder, take the roll.
Carrie Dove, Bruce Fox, John Garrett, Bob Pitts, Gary Selvey, Paul Schaefer. It's unanimous.
Thank you, Ms. Schroeder. That concludes consideration of the bills. Mr. Pitts, wish to
Madam
recognize?
Chairman.
Yes.
With your permission, I'd like to see if I could get advisory council concurrence to how this is transmitted to the General Assembly. As it's extremely important beyond the position of issue is that the legislature understand what has caused the council to take this position. I'm going to suggest, and see how far it flies, that as the voting members know, there has been a collection of some concerns that members of the council have. I would like to suggest that those be included in the staff report as to the rationale behind why the council has taken this vote today. And if there was not objection, I would like to add one item to that list, maybe two. The first is that there's been no assessment of the financial needs. Excuse me, let me change that. No assessment of the possible transfer of legitimate injured worker financial needs to Social Security, Disability, Medicare, and 10K. The second, while all the regulators are in the room, and the first item on that list, if you all agree, is understanding at this point that the Tennessee Department of Commerce and Industry and the Workers' Comp Agency both still maintain serious concerns and have this bill flagged. And I think that needs to be in the record. In conclusion, I would suggest that with our report, that legislators should be provided with a copy of Abby's analysis and probably the analysis done by PCI if you all do not have objections with it properly titled as to who it's from. I would assume this would be of great aid to the legislators in understanding the vote here today.
To the extent that's a motion, Mr. Fox seconds. I think a voice vote would be sufficient on that to show. Mr. Dove was. Okay. And I'll gently remind the members of the council that discussion needs to be on the record. So, Mr. Dove, that's okay. We have a motion to, as far as the way the council's action today would be transmitted to the standing committees with some additions by Mr. Pitts. We had a second from Mr. Fox. I think we're looking for a general concurrence of the members of the council. Just to be on the safe side, we'll do that by a roll call vote. Ms. Schroeder. I'm sorry, Mr. Garrett.
Mr. Pitts would allow me. I just wanted to make sure he wanted to include the document entitled Advisory Council Comments on Senate Bill 721 and House Bill 991. Did you want that just for clarification? Is that going part of the packet?
He was actually looking at the chart that was. Do you see the chart that's sideways landscape? Yes. The chart and then the PCI page right there that you have in your hand. It's a 2-page chart and a several-page PCI document.
So you're just looking for the chart from the department PCI statement.
And the amalgamation of observations of our concerns. Correct.
Thank you, sir.
Mr. Dove. If the chair can kind of step in for a moment, let me kind of explain what the process is. After each meeting, Ms. Schroeder goes back to the office and prepares what's basically a very detailed set of minutes that reflects the action of the council and the discussions, and typically reflects the rationale of the statements of the interested parties for transmission to the standing committees. And I think what Mr. Pitts is suggesting, that along with that, we include those two documents, the chart that Ms. Hudgens prepared today and the PCI comment. So I think when he says amalgamation, he means what we prepare internally. Got it? Any further discussion before the council votes? All right, Ms. Schroeder.
Carrie Dove. Bruce Fox. John Garrett. Bob Pitts. Gary Selvey. Paul Schaefer. It's unanimous.
Thank you, Ms. Schroeder. We'll make sure that report's prepared as soon as possible. Is there any further business to come before the council today? Seeing none, do I have a motion to adjourn? Second, we are adjourned, subject to the call of the chair. Thank you.